Welcome, and thank you for joining us for our webinar today on the life cycle of estate planning. We appreciate you taking the time to find out exactly how an estate plan transitions and evolves over time. My name is Kara Musa, and I'm the Director of Marketing for the Kopenbarger and Kopenbarger Law Firm. I have been here for over 5 years, and I truly enjoy what I do. We have the opportunity to help so many families, and we take pride in working as a team, not only within the firm, but also with our financial advisors and CPAs and other people that are instrumental in creating the best plan for you and those you love. In the chat box, you'll see a link to partner@kopenbarger.com. If at any point during the webinar you decide you want to take the next steps to protect your estate, please click that link and provide us with your first and last name, your phone number, and then we will reach out to you and book an appointment with one of our certified specialists today. Your presenter is our founder, Lloyd Kopenbarger, and he has been practicing law with us for over 40 years. Lloyd has a master's in taxation and is a certified specialist in probate, estate planning, and trust law by the California Board of Legal Specialization through the State Bar of California. Lloyd has trained dozens of attorneys throughout his years and has led our firm in serving over 30,000 clients across the state of California. You'll find that Lloyd has a real passion for giving back to the community, and I'm so excited for him to share his story with you. So without further ado, I'd like to welcome attorney and founding partner, Lloyd Kopenbarger.
Thank you very much, Kara. It's so good to have an opportunity to share with you today about something that I find is extremely important, regardless of where you are in what we call the cycle of life. And so we're going to go very briefly over the agenda that I hope to cover today and talk about the areas that we're going to give special attention to. First of all, we're going to talk about the tools that are available to us to deal with various areas of our life that can create legal issues for us if they're not properly attended to. We're going to talk about the essential documents that every person who is 18 years of age or older needs to consider immediately, and the ones that, as their life evolves, will become necessary for them to protect and provide for themselves and the people they love and care about. Then we're going to talk about the stages of life that we go through. I've now reached the point where I'm probably in the final cycle of life. I have children, I have grandchildren, I have great-grandchildren, and as I've lived through my life, when I had small children, I had one set of concerns and difficulties to deal with. When those children reached adulthood and started families of their own, that changed plans a little bit. And later, as you reach the point in life where there's more of life behind you than there is in front of you, it changes your focus on how do you leave behind not only an inheritance, but a legacy for the people that you love and care about. And those are the kinds of things that we're going to be discussing today. What I'd like to do is to start with the very first step in this planning that needs to be considered by every single person who's over the age of 18 years of age. And that is, you need to consider an advanced health care directive. You also, as you start to acquire financial resources, need to have a durable power of attorney for financial matters. That's a document that will allow you to have someone else be able to take care of business and legal matters for you if you can't act for yourself. Those are essential documents, even for very young people. And so let's discuss them in more detail. An advanced healthcare directive is a document that gives authority to another adult to act on your behalf for healthcare decisions. Now remember, as long as you're able to make decisions for yourself, no one can interfere with your ability to communicate with your doctor and make those decisions for yourself. But if you reach a point where, because of medication or because you're in a coma or other circumstances where your doctor cannot communicate with you, then it's critical to have someone who has the authority to step in as your representative to make sure your wishes are considered as medical decisions are made for you. This is a necessity for everyone over the age of 18. What a lot of parents don't realize is that when your child has their 18th birthday, as far as the law is concerned, they now become a separate, independent human being. And you no longer have the authority to make decisions for them. And so it's critical when they're in this beginning phase of adulthood that someone be empowered to take medical steps for them if a crisis situation were to occur. And so I would encourage you, if you have grandchildren who are 18 years of age and older, you have children who are 18 years of age or older, or if you're a young person who is listening to this, who has reached the age of 18, and you don't have an advanced healthcare directive, you need to obtain one. Now, that document allows you to establish what your wishes are in the case of death. It allows you to determine what your wishes are in the case of certain kinds of medical treatment. It allows you to determine whether you would want to continue to be kept alive on life support if there was no longer any significant reality of you recovering and your life continuing. And so it's a very important decision-making document for every person who is over the age of 18, and no one else can act for you without this legal authority permitting it. And again, I want to emphasize, husbands, you cannot make a decision for your wife unless she has an advanced healthcare directive. Wife, you cannot make decisions for your husband unless he has an advanced healthcare directive permitting you to have the authority to act for him. And parents, you cannot make decisions for your 18-year-old or older child unless they have an advanced healthcare directive giving you that authority and responsibility. The second document that everyone who has attained the age of 18 and also has financial resources should consider is a power of attorney. This power of attorney allows you to give to another person the authority to carry out certain responsibilities that you define. It may be being able to deposit money at your bank for you and write checks out of your bank to satisfy your debts and obligations. It may be the ability to sell a car if you were unable to act yourself. It may be the power to sign papers to buy real estate. The durable power of attorney is a document that does not become null and void if you become incapacitated. It allows someone to be there for you anytime you're unable to be there for yourself. And so it's a very important document for anyone who is starting to acquire financial resources or who has acquired financial resources. Another document that people should consider is a will. Wills are confusing because there are several different kinds of wills that we have the ability to utilize, and they fill different roles depending on our circumstances. What I'm going to talk about right now is what I call a standalone will. This is a will for someone who does not have a living trust and who the will is going to designate the people who will receive their financial resources that do not have beneficiary designation provisions attached to them. Now, who are the people who should consider a will? In my opinion, wills are not for everyone. Here in California, if you are a person who doesn't have any real estate, if you're a person with a total estate that would be subject to probate of less than $166,250, you are a person who should consider a will, because it will take care of your personal responsibilities of distributing your assets in the event of your death. Remember, it will go through the probate process, but as long as your estate is less than $166,250, it is not a formal probate, it is an informal probate. And there is a world of difference between an informal probate and a formal probate that requires the court to be involved and requires the legal notice provisions and the statutory requirements of the probate process. People who are on the bubble in this area of a simple will or a standalone will are people who have minor children. If finances are a critical issue, then a will is better than nothing, because it allows you to name the people that you would want to be in charge of the care of your children in the event of your death and you're being unable to provide for their care yourself. However, the children's estate, whatever you leave to the children, will be under court supervision under that will until they attain the age of 18. It gives each child their share of the inheritance as they attain the age of 18, which means that younger children are sometimes left shorted in this kind of a disposition process. And so if you're a young person with minor children and you're trying to decide whether or not a will is appropriate for you to take care of your responsibilities to protect your children, you really need to sit down with an attorney who's knowledgeable, and you determine, based on the attorney's advice to you, whether or not that will in fact be sufficient to provide the protection for your children that you believe is appropriate. Remember, a good attorney does not write your will. You write the will with your good attorney, and the attorney satisfies the legal requirements using your wishes to satisfy your requirements to provide for the people you love and care about. The purpose of probate, and I mentioned probate a while ago, let me take a moment to explain what probate is. Probate is a legal procedure that the law requires when someone dies with property in their name as an individual person. The purpose of that probate process is twofold. First, it is to protect society, and that is to make sure that someone doesn't die and leave obligations behind. In other words, to be kind of flippant about it, is to make sure that you don't stiff someone when you become a stiff. And so the will going through probate requires the court to make sure that all of your debts and obligations are presented publicly so that people that that you're obligated to have an opportunity to come in and be paid before anyone else receives any part of your estate. The flip side of this is probate also allows your estate, the representative of your estate, to collect debts and obligations that are owed to you, so that you can't be stiffed by the living after you are no longer here to enforce your rights to the obligations that are owed to you. But the most important aspect of the probate process is it has the ability to shift legal ownership from someone who's deceased, who no longer can do it themselves, to the living who are entitled to receive it, either by the provisions in your will or by the provision of state law. It transfers that ownership from someone who can no longer transfer that ownership to the living, so that they can use and enjoy that property and have it in their name legally, so they can continue their life and their activities. Now, when I talk about probate, I like to use the analogy of the big law and the little law. When you go through probate, you're dealing with the big law, and that's the law of the state of California, the law of the United States of America. And if you could visualize a stack of books containing the laws that deal with probate and the laws of real estate and the other laws that are involved in the probate process, you'd be talking about a stack of books several feet high. If you don't write your own law, you will always be governed by what I call the big law. The problem with the big law is it's expensive to administer. The courts have rules that have to be followed for the big law to be satisfied. And so many times people recognize that the process of probate requires you to follow the state laws, or what I call the big law, that almost always results in lengthy delays in settling the estate. With this COVID crisis, we're seeing estates not even being heard for weeks and months after the petition for probate is filed. More importantly, the control of the estate is with the court, not with family members. And so many times, if you have a family business or you have family needs that need to be addressed promptly, the court is not as attended to getting to those circumstances as perhaps someone who is more attuned to the needs of the family would be. And then finally, the probate process is expensive. You're talking about, in many cases, 5 to 7% of the value of your financial resources being paid to the attorneys and to the court and to the executor to go through this legal proceeding that we call probate. Now, the alternative to probate in our society, there are two alternatives to probate. One of those alternatives you probably already are using. If you have an IRA, or if you have an annuity, or if you have an insurance policy, it is quite probable that with that contract that you got when you purchased that financial product, you were asked to name a beneficiary who would receive the benefits under that product in the event of your death. I call that provision by operational law. That does not go through the probate process unless you don't name a beneficiary to receive it in the event of your death. The other alternative to avoiding the probate process is to create something called a revocable living trust. Now, what is a living trust? A living trust is nothing more than a contract that a person creates to establish what they want to have done while they're living if they're unable to be in charge themselves. In other words, if they have a stroke or if they're in an accident or some other circumstance where they cannot act for themselves. And it allows them to name the people that they want to be in charge as various circumstances arise. That person who is the creator of a trust is not the attorney. The attorney merely helps draft the contract so that the contract provides the provisions that the person who is creating the trust desires. We call the person who creates that contract the settlor of the trust. Now, that's an archaic English word, but it's a very powerful word, because no one will ever be the trustee of a trust no one will ever be the settlor of the trust except the person who creates the trust. The person who creates the trust has the ability to name who will be the other important people in the trust. The settlor, in other words, sets the terms of the trust contract. The settlor gets to name the person who carries out the terms of the contract. We call that person who sets out the terms of the contract and carries them out the trustee of the trust. Now, the trust documents can be created under different circumstances. What I've been talking to you about for the past few moments has been a living trust that's created during your lifetime. It can be either revocable or irrevocable, and revocable just means you're able to change it without any particular formal action that has to be taken other than make a written amendment. Irrevocable means that it's more difficult to change, and many times it can only be changed by the terms of the contract or by court authorization. We use irrevocable trusts to plan for income tax savings, for estate tax and gift tax protection. The revocable trust is almost exclusively to be used to provide protection from probate and to provide protection from conservatorship if you become disabled during lifetime and cannot handle your affairs. Testamentary trusts are another type of trust. Those are created by will and are almost always required to go through the probate process to be formally implemented. Irrevocable trusts can be set up so that when you die, there are provisions for your children under the terms of the trust. Those kind of provisions can be either in an irrevocable trust or a revocable living trust. They can be created through a living trust, or they can be created by a testamentary trust in the probate court. Again, I want to review with you the terms of the trust uses. The person who creates the trust and sets the terms is the settlor. The person who manages and invests the trust assets and who is required to follow the terms of the trust is the trustee. The person who is named to receive the benefits from the trust are called the beneficiaries. In most cases, when people create a living trust, they fill all three roles. For example, if I were to create a living trust, and I have one, for my wife and I, we would be the settlors of the trust. We would decide what the trust said and how the trust was to be administered and carried out. We also have named ourselves the trustees of the trust. By being both the settlors and the trustees, we have the ability to do anything we want. If the trust is no longer what we wish, we can amend it and thus carry out whatever our wishes are at any time, acting as both settlors and trustees. Remember, there will never be any settlor except the person who creates the trust. There will be other trustees if the trust is allowed to continue until you become disabled or deceased. The beneficiaries of the trust initially will also usually be the person who's creating the trust. In Laura's and my trust, all of the resources we have are held in the trust for our benefit, and we use them for whatever purpose we wish as long as we're living and competent. There are specific provisions to provide when the time comes that we're both gone and we want what we have to go to the people that we wish to receive it. And in the trust, we name who we want to receive it, and we are allowed to put conditions on how they receive it to provide additional protection. And I'll talk about that a little more later in our session. The primary benefit of the revocable living trust is that it avoids the cost and delay of probate. And it almost always is desirable if your estate is more than $166,250. It also protects your privacy because unlike a will that has to be publicly recorded with the court and published to the public if someone wants to know what was in your will, a living trust is private. And only if the living trust is subjected to litigation can anyone know what's in that living trust. And even then, the courts in most cases will protect the contents of the trust by restricting the information in the trust to a need to know basis. So somebody can't just find out you died and decide they want to know what your business is and how you want to provide for the people who are part of your life. So the trust allows you to maintain privacy even when you're no longer here to protect that privacy yourself. The trust also allows you to structure your estate in such a way that you can eliminate federal estate taxes. And right now, the proper use of a living trust can allow a person to protect up to over $23 million with a husband and wife over both of their deaths. Now, there's a possibility that's going to change in the next 5 years so that it will only allow the protection of about $11 million, but that still is a significant amount of wealth that people can protect using a properly prepared living trust. The living trust also eliminates the need for court supervised guardianship for your children and for conservatorship for disabled adults. Let's say you have a child who has a special need. You can provide for that special need in your living trust. It will not cause them to lose their governmental benefits if they're receiving SSI or some other form of governmental assistance if it is properly prepared by the attorney who prepares your trust. It also assures, and this in my opinion is the most important factor, it assures that your wishes will be carried out, not the wishes or the desires of a probate judge who is carrying out these activities. Remember though, with a living trust, there is a critical point that you have to ingrain in your mind. If you have a living trust now, or if you're going to create a living trust, a trust only protects what's in its name. And so you must make certain that the trust becomes the legal owner of everything you have. Now you might say, well, I don't want to put my holdings or my property in out of my name. Well, you don't if you're the settlor of the trust. For example, in Laura's and my trust, we own our home in Laura and Lloyd Kopenbarger, trustees of the Kopenbarger Revocable Living Trust. And by having that name trustee after our individual names, we have shifted the ownership of that property legally to the trust where it does not go through the probate process in the event of our death. If we had not titled our home in the name of the trust, then it would go through the probate process. And remember, the probate fees are based on the gross value of the property, not the equity. And in California, where the gross value of a property may be $800,000 or $900,000 or more, and you may owe $600,000 or $700,000 on that home, particularly if you're young and you're acquiring an equity in it, the fees will be based on that gross value, not on your equity. And so that can create a significant hardship for people who have a substantial indebtedness against their home or any other property that would be subject to probate. Now, if you do fail to put property in the name of the trust, it doesn't just fall away and is lost. If the trust is prepared by someone who is knowledgeable, they will create with that trust a special document called a pour-over will. The best way I can describe a pour-over will is it's like a safety net, so that anything you leave out of the trust drops into that safety net of the pour-over will, and the pour-over will puts it in your trust so that it's distributed to the people that you want to receive it. If you die, that pour-over will is the only way to get property that is in your name as an individual into the trust, where the trust can administer it and use it as you wish for it to be used. If you're still living and you've left something out of the trust, then the financial power of attorney can be used to transfer that property directly into the trust by the person you've named as your financial agent under the power of attorney for financial matters. Now, the pour over will, in addition to accomplishing the purposes of getting property into the trust, also allows you to name an executor to carry out the duties of handling property that's been left out of the trust. It can allow you to name a legal guardian for minor children. I don't like to do it, but it can transfer personal effects. I prefer to use a provision in the trust where we transfer what I call your stuff to the trust. And then when you die, that stuff is in the trust. And you can either leave a written memorandum as to who you want to receive your stuff, or it will be divided up based on its value to the people you want to receive it. Again, stuff is important. And so I recommend that you take the time to put it in your living trust. I recommend that you seriously consider writing letters of instruction, giving specific things to give different people, and then telling them why that item was important to you during your life and how you hope it will be a benefit and a blessing to them now that it's theirs. This is important things from a standpoint of keeping family unity when you're gone, because it's not the oil wells in Oklahoma or the high-rise office buildings in Los Angeles that create family fights. In my experience, it's your junk. It's the stuff that you really didn't even realize was important, but as your kids grew up, they identified that with you. And once you're gone, that is the only physical manifestation that they have of you, and they will fight like tigers to see who gets it. And sometimes the wounds they give each other never heal. And so as responsible adults, we need to try to make sure that those kinds of circumstances are not allowed to occur in our families as a result of our failure to carry out our responsibilities. And also remember that if you leave more than $166,250 outside the trust, that pour of a will is going to be probated. And there's expense associated with that, and there's delay associated with it. Now, let me shift from talking about these basic documents to talking about the phases of life. And let's start with that first phase of life. With young adults, they have finished their living with their parents. They are now legally adults living their own lives. And at some point in time, in most cases, they will establish a family. And that family will be made up of the mother, the father, and the children of that couple. Those children will be the responsibility of both the mother and father. That responsibility does not end with a death or with a divorce or with some other separation of some kind. That responsibility continues until those children reach the age of majority, which is 18 years of age. It is extremely important that the parents of those children develop a plan to make sure that in the event of death or incapacity, those children's needs are provided for. And that means selecting people that will raise them and give them the values that you believe are important for people to have as adults. It means establishing the financial resources to provide for education and other needs. It means considering the impact that receiving additional children into the home of the guardian will create for the guardian. There are so many of these aspects that are so important that most people, when they write a will, never really think about what happens if they're no longer there. My wife and I had friends back when we were a young married couple with minor children, and we would often go out with this couple, and the husband would just literally write out a page and a half of instructions to the babysitter. And one day my wife said to him, she said, "Terry, you leave more instructions when you're going to be gone for the evening than you've left if you were to be gone permanently." And it was absolutely true. He had never taken the time to create a will or instructions, permanent instructions for the care of his children if he and his wife had been killed while we were out or under some circumstance of life. And so it's critically important that as a young family, you deal with the issues of those children. That phase of your life is going to last at least 18 years between the birth of your child and the time they reach age 18. And if you have several children, that age is going to stretch out to more than 18 years, depending on the ages of your children. Also, remember that in California, if you're a homeowner, you have a property that is quite valuable. And in most cases, it has increased in value since you purchased it. And if you keep it over a period of many years, it will almost always increase in value substantially. Remember, unless that home is protected from the probate process, it can be a substantial expense to get that property out of your name as a deceased person into the name of the living people that you want to receive it. And in my opinion, if you have received assets by inheritance or you've acquired them yourself through your efforts of over $166,250, you need to consider seriously creating a living trust to protect them. And in any event, you want to save the people that are required to settle up your affairs the costs and the hassle of the probate process. Now, how do you establish a plan? And this applies to all of us, but I'm going to talk right now about the people who are young couples. And you see the picture of the young man and woman and their young son, I believe it's a young son, walking down the pathway of life. In order for them to do a proper plan, they have to decide what's really important in their life and in their value system. They have to decide how they want to share their life and their legacy with this child if they're not around to do it personally. They have to decide who is going to be responsible for the care of that child. They're going to have to decide at what age that child becomes mature enough to receive his inheritance or her inheritance without it being supervised by another adult. You have to decide who is responsible enough to assume that responsibility for the care of your child if you're not there to provide it yourself. Many times you will need to consider not only the person who cares for your child, but you'll also need to provide care for the person who will handle your finances until your child is mature enough to be managing themselves. This is a difficult dilemma because sometimes the person who is best to raise your child is not a person who is best to manage your financial resources. And so that requires you to give consideration to whether or not one person can handle the entire responsibilities or whether the responsibilities need to be divided. Also, remember that all of us are mortal, and the person you name as a trustee or as a guardian may well be taken after you're taken. And so you need to have a first and second choice at a minimum, and I prefer to have a first, second, and third choice for these position responsibilities. The important thing is for you to give thought to it while you're alive and well. I realize sitting around thinking about the possibility of you no longer being here is not a pleasant endeavor, but it's a very important one. You can give provisions in your plan to deal with substance abuse and with people who are not wise with money. For example, in all of my trusts now, I put provisions in for uh, abuse of drugs. We live in a time when you can become addicted without knowing you're doing anything that would cause you to become addicted. There are literally millions of people in our society who are addicted because they took Oxycontin and didn't realize the addicting qualities of that drug. They took it to relieve pain and found themselves locked in a cycle of having to continue to abuse that drug to avoid the pain the drug was inflicting. And so this is an important issue. And only if the client tells me they don't want it in their documents do I leave it out, because I think it's such an important provision. It gives the person who's the trustee the ability to determine when a person who is under the influence of drugs or other addictive substances, when they are no longer subject to that drug overriding their other judgment. You also, in a properly prepared trust, can make provisions for what happens if you or your significant other, your spouse, predeceases you, or you predecease them. One of the things that you have to be concerned, and this becomes more of a concern as you live your life, is if you've acquired significant financial resources, if your spouse were to remarry, there is always the possibility that what you and your spouse have acquired together during the marriage might end up in the hands of a stranger to your marriage, and your children might end up being disinherited by that process of being left out as a result of remarrying. You also can set up plans so that the children's inheritance can never be taken away from them by a divorcing spouse or by lawsuits or by bankruptcy. So there are really significant provisions that you can put in a properly prepared trust, whether you're at the first stage of life or whether you're at the second or third stage of life, that can provide really significant protection, not only to you, but to the people you love and care about, and make their life better than it would have been had you not taken the time to wisely plan how they would receive what you want them to benefit from your life. As we live our lives, other planning tools become important. Life insurance, I think life insurance is really important for every young family. And as inexpensive as term life insurance is today, there's no excuse for any family being faced with economic catastrophe if the breadwinners are taken. For literally pennies a day, you can get a significant amount of insurance to provide protection for your children and for your spouse. You also, as you get older, can create standalone retirement trusts to take your retirement funds, your IRAs, your 401ks, and better protect them for the benefit of the people who will receive them when you no longer need them or use them. If you have animals, you need to seriously consider in your trust or in a standalone trust having provisions for the care of those animals in the event of your death. If you are a person who's charitably minded, we can create charitable trusts that can save taxes and can also provide you a guaranteed income for as long as you live. If you're a person who has firearms, we live in a society that is hostile to the possession of firearms. And so in many cases, it needs to be carefully taken care of. And it all depends on your individual circumstances, whether the guns you have are registered or whether they're not registered, what has to be done by the recipient of those weapons when the time comes that you're no longer here to enjoy them, and make sure that they're handled in such a way that no one is subjected to potential criminal liability trying to carry out your wishes as it relates to that type of financial and personal property. We also need to be concerned about rental property. If we have a child with special needs who is receiving governmental benefits, we need to make sure that in our attempt to provide for that child, we don't deprive them of the governmental benefits that they would otherwise be entitled to. And as we get older, one of the things that we need to be cognizant of is there are ways in the hands of a skilled attorney who is knowledgeable. And I'll candidly tell you, there are not that many. Most attorneys will tell you it can't be done, but you can structure your financial affairs in such a way that you can qualify for Medi-Cal and keep your financial resources from having to be dissipated to provide for long-term skilled nursing care in the event you have a serious illness later in life. And another thing that you can do that I think is important is if you've been blessed with financial resources, and even if you haven't been, I think it is desirable for you to create a family constitution, to tell your family what values you believe are important in your life and that you hope that they will consider as they live their own life. Now, as we get older, your minor children become adults. I've attained that stage. My minor grandchildren are no longer minors. They are adults and they're having children. You become a grandparent. And in my case, I'm a great grandparent. You refinance or buy a home or you pay your home off. A beneficiary that unexpectedly begins to be addicted to some kind of a substance. A beneficiary gets married or divorced, and depending on who they marry or who they are divorced from, that sometimes requires you to take steps to make adjustments in the provisions you made for them. And a more critical situation is where someone that you have relied on to be there for you if you couldn't be there for yourself either becomes ill or they pass away themselves. You need to consider what I've already talked about a little bit earlier, and that is your spouse predeceases you and you remarry. Now, I think this should be dealt with while both you and your spouse are living so that you determine whether or not the entire estate can end up in the hands of a stranger to the marriage or whether the surviving spouse has the benefit of all of the assets of the marriage for themselves, but they can only give their portion to a second husband or wife. And then also in life, things change. Sometimes we have great relationships that go bad. And sometimes people don't want to have anything to do with us anymore. And as some of you know, I'm a person that I like to believe I'm a person of faith. God gives us free will as it relates to Him. And I believe that people have a right to decide whether they want to have a relationship with us or not. And we have a responsibility to honor their wishes. If they don't want to be part of our life and they don't want us to be part of theirs, I think it should be reflected in our estate planning documents. I think it's wrong to leave the example to your children and grandchildren and great-grandchildren where you provide benefits to someone who has rejected you and doesn't have anything to do with your family. Now, that's just one man's opinion, and it's worth exactly what I'm charging you for today. But it's something that is so painful and is so difficult to deal with that sometimes it helps to have the perspective of someone whose heart is not being torn apart by the thought of accepting this rejection. Now, let's talk about when you live a little longer. And I'm getting close to this point. Well, I'm past this point. My grandkids are in their early 30s now, some of them. All of them are adults. Some of them have established families of their own, and they're starting to have children of their own. I told you at the beginning, I have 8 great grandchildren, and gosh, how wonderful they are. Now, maybe nobody else would think they're wonderful, but to me, you just can't believe. I had the privilege last weekend of working. Some of you know I have airplanes, and we went out to the airport, and these two stalwart young men, 14 years old, stronger than I am, were helping me do things around the airport that I couldn't believe. These babies that I remember from just a few weeks ago are now suddenly young men getting ready to reach high school and adulthood and the responsibilities that come with that in life. It gave me an opportunity to talk to them a little bit about the things in life that I believe are really important, the things that make the difference in whether your life is one of enjoyment and pleasure, or whether you're constantly trying to deal with the problems that were made by wrong choices and wrong decisions. That doesn't mean that they're going to listen to me. It doesn't mean that they're not going to make mistakes and bad decisions, but it's not going to be because Grandpa didn't say to them what he believed were the keys that you use to decide whether a judgment is a good judgment or a bad judgment. And I'm confident that all of you have lived life enough that you know there are certain things that are toxic and there are certain things that are healthy and are beneficial. And we need to, in life, encourage the people we love and care about to avoid the toxic and to choose the healthy and the beneficial. It also allows us, in the right circumstance, to sit down with our children and our grandchildren and tell them what we hope for their life, and use some of that stories from the Old Testament where the patriarch and the matriarch blessed the family and kind of literally shared what they hoped life would bring to the people they loved and cared about. And also, at this point in life, it allows us to take care of our own long-term care arrangements. It is difficult dealing with the advancing years. As our bodies start to decline and fail us, it puts a burden on us that is almost unbearable, and it can create a burden on the people we love and care about that is unbearable unless we plan and make arrangements to protect them. And the only way to do that, in my opinion, successfully, is to sit down with an attorney who's knowledgeable and talk about whether or not Medi-Cal planning is appropriate, talk about how to properly structure that kind of planning if it is appropriate, to talk about whether or not you need tax planning. Those are the kinds of things that really need to be reviewed as you reach that stage of life where the past is much longer behind you than the area of life in front of you is. You want to make sure that you have not inadvertently created a situation where probate will be required or where someone is likely to litigate and try to change your estate plan. Proper planning by an attorney where they know there is the potential of conflict can, in many cases, eliminate the potential for that conflict occurring. Again, even when you create the right documents at the beginning of your life as a young adult, those documents are going to almost certainly require change as the circumstance of your life changes. And so, in my opinion, once you have a properly prepared plan, you should examine that plan carefully every 2 years. Now, I'm not saying you should come in and sit down with an attorney, but what I am saying is you need to read it and you need to ask yourself, is this still what I would want to happen if I were to pass away? If the answer is yes, put it away and wait another 2 years and do it again. But it's really important that you make certain that you don't create, by failing to review and make decisions, unnecessary legal situations that will harm your family. Now, I've spent almost an hour talking to you about these issues. The question becomes, since you've been listening to me for an hour, you may have already made a decision as to what you want to do, and it may not be one that will be governed by what I'm about to talk about. But I'm going to encourage you to consider meeting with the law firm and going over your personal circumstance, even if it's just to sit down and review the documents you already have and ascertain whether or not there's any additional fine tuning that needs to be done. Now, why choose Kopenbarger? Well, first of all, because of me. I started this law firm in 1979, and we have been blessed to serve many people during that almost 40 plus year period. It is more than 40 years. It was 40 years last year. We have a firm made up of people who are specialists in this area of the law. We've already talked a little bit about their credentials, but there is significance to a person who is a certified specialist. I unfortunately have many occasions to review documents that were prepared by attorneys who clearly didn't understand the law that is governing the creation of wills and trusts. And that always ends up in someone like our firm having to come in when you die and go through a very expensive process of resolving those problems. I used to be very concerned about do-it-yourself documents, and I still am. And the reason I am is not because they take business away from us, but because they create the wrong kind of business for us. It is not pleasant to deal with a family who's dealing with a will or trust that didn't do what it was supposed to do. And everybody is mad at each other. Everybody's mad at the attorney who prepared it. And everybody is wondering what in God's name were they thinking about when they created this horrible mess. And the reality is the person who did the document, the person whose will or trust it is, was relying on expertise, but that expertise was not there, and it created a problem. In Kopenbarger and Kopenbarger, you're not going to be dealing with someone who is a passing acquaintance with wills and trusts and estate planning. These people are all experienced attorneys who've been doing this for a number of years. We also, as a firm, have over 300 years of combined experience. We have certified specialists, as I've already indicated. That is highly important. But even more important than the attorneys are our skilled legal assistants. My assistants, to give you an example, one of them's been with me 32 years, one's been with me 17 years, one's been with me 15 years. We are blessed with wonderful people who care about our clients and who care about the work they do. And that brings a value that I don't know how to quantify. There are, in spite of what I said, there are many good attorneys, but I've never been around a law firm or knew of a law firm that had the quality of support staff that Kopenbarger and Kopenbarger's been blessed with. We have offices in San Diego County, in Temecula, in Riverside County, in Orange County, in LA County, in Santa Cruz, California, in San Jose, California, and in Sacramento, California. And of course, as you're seeing today, one of the benefits that our firm has, and we were fortunate to have this in place when the COVID crisis arose, and that is the ability to have Zoom appointments. For example, last week I had a meeting with a client who lives in Mumbai, India, whose financial planner was in New York City, and I'm sitting in an office in Orange County. So this ability to have virtually boundless reach to serve people's needs is something that is truly valuable. We created this because I realized as I got older, my clients were getting older, and sometimes it was difficult or even impossible for them to conveniently come into the office. And this allows us to meet with them and with their families in their home with us in our office. And in a time like this where we're dealing with this terrible pandemic, it allows us to do it in a way that's safe. So those are some of the circumstances that you might want to consider. These are the people who would serve you as attorneys. We have tried to stair step our attorneys so as some of us older ones are taken from the scene, there will be younger attorneys with the same credentials and same value systems there to take our place. And so with that, I'm going to turn the session back to our hostess. Kara, would you help these folks in any way possible to take care of their needs?
I sure will. Thank you so much, Lloyd. Again, we would like to thank you for attending our presentation and truly hope you received valuable information about estate planning that you might not have already known. Remember, you worked hard your entire life to build what you've got, and whether that's a little or a lot to you, it matters to us. In honor of Estate Planning Awareness Week, we are waiving our consultation fee of $250. Do not wait to schedule. Our calendar is filling up very quickly, and in order to see one of our attorneys before any changes in the law, you must schedule now. To schedule your free consultation today, please click the link in the chat box, which once again is partner@copeandbarger.com, and give us your name and phone number, and we'll reach out to you shortly. If we didn't get a chance to answer your questions today, we will most certainly answer it during your complimentary consultation with one of our certified specialists. Our marketing team will be sending out a recording of this presentation to you this afternoon, and we encourage you to share this information with family and friends who could benefit. Lastly, we want you to know that we are here to help you through all of life's changes. And whether you need to establish an estate plan for the first time or to review an existing estate plan, we're here for you. In conclusion, I want to leave you with a phrase that Lloyd has used for many years, and that is, if your attorney isn't there when you need them, then you don't need them. Have a wonderful rest of your week, and thank you again for tuning in today.